and you're not going to pay it anyway. My gut's telling me that you don't have the money to pay it off anyway. That's silly to me. 3 years of the court is going to order. Wow.
Current Mr. Ronning has told me, has given me authority to say that he is not at this time dissatisfied with the court's ruling. However, and I appreciate his accepting respect.
Well, just has to be on the record. So the court is going to order. I'm going to order 10 years revocation of driver's license. 10 years ignition interlock device. Awesome.
Judge Taylor didn't like it.
I feel like it was either you or Sheila had one Denny once where the whole thing was they had an identical twin.
Wasn't me.
Oh.
Life race. 26 CF 10, State of Wisconsin versus Stephen Ronning. The state appears through District Attorney Kevin Schmidt in person. Mr. Ronning appears in person in custody with his counsel, James McLaughlin. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. McLaughlin, can you recite it for the record?
Yes, you're right. My understanding is that Mr. Ronning my understanding is that both parties will be making the same recommendation that the defendant be sentenced to 3 years incarceration in the Wisconsin state prison system, but the sentence with any resulting extended supervision, the defendant Olmsted County or sentenced out of Olmsted County, he's currently has been transferred here from the Minnesota prison system. Further, Your Honor, I did not raise this explicitly with the district attorney, but I would be asking the court to make Mr. Ronning eligible for the extended supervision program as part of this sentence. Because he was held without bond, I do not believe therefore he is entitled to credit, according to my understanding of Wisconsin sentencing statute.
Okay.
And as the court notes, as part of the defense sentencing for the court's consideration, the defense did submit a sentencing memorandum by my client service specialist, Miranda McClevey, on Mr. Ronning's behalf.
Yep, it's red. It's marked.
Thank you.
What do you mean by extended supervision program?
If he has to serve any part of his sentence in the Wisconsin system and becomes earned release eligible, if there is any balance of his sentence that's left to be served, it would be converted to extended supervision.
You mean ERPSAP, right?
Yes.
Okay. Sorry.
That's what I mean by that.
But if and only if he sat completely day for day, the mandatory minimum.
Correct.
Okay. I have in front of me, Mr. Ronning, a plea questionnaire waiver of rights form along with the jury instructions as it relates to this offense. Did your attorney go over these documents with you?
Yes, he did.
Did he go over them essentially word for word with you?
Yes.
And do you understand it completely?
Yes, I do.
And did you sign the second page of that document?
I did, yes.
So you're telling the court you fully understand everything that's contained on this plea questionnaire as well as the jury instructions?
Yes.
You're pleading guilty to an OWI 7, 8, or 9. You're 58 years old. You have 11 years of schooling. You can read, write, and you understand the English language. No drugs, alcohol, or other medications in your last 24 hours. No treatment for a mental illness or disorder. All correct?
Yes.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney thoroughly go over with you the maximum possible penalties you face?
Yes.
Because you're charged with crimes, you are entitled to constitutional rights. Each of these rights is listed on the plea questionnaire. Did your attorney thoroughly go over these rights with you?
Yes.
Do you understand them completely?
Yes.
Do you need me to go over these rights with you in any more detail?
No.
So you understand them completely?
Yes.
Do you understand that by pleading guilty, you are waiving and giving up these rights?
Yes.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes.
Do you understand that you're pleading guilty to a felony? As such, you will no longer be able to use or possess a firearm for life.
Yes.
You will no longer be able to vote in any election until your civil rights are restored.
Yes.
Do you understand that the state would have to prove for operating a motor vehicle while under the influence, 7th, 8th, or 9th offense on or around October 25th, 2025 in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant? That is a Class F felony. Do you understand what the state would have to prove?
Yes.
Do you understand the maximum possible penalty could be a fine of up to $25,000 or 12 years and 6 months of incarceration, or both?
Yes.
And pardon me, Your Honor, but the record can reflect, as the court was reading it, a copy of the information reciting that count 1 is directly in front of the defendant.
Thank you, Mr. McLaughlin. So do you understand that there has been an agreement that's been recited on the record between you and the state as a recommendation for sentencing to the court? Do you understand that?
Yes.
Do you understand that I am not bound to follow that recommendation?
Yes.
Said differently, I could sentence you all the way to the maximum possible penalty if I find it warranted. Do you understand that?
Yes.
Do you also understand that with this crime, that there's a mandatory sentence that the court shall impose, a bifurcated sentence under Wisconsin law, with the confinement portion of that sentence being imposed on you for not less than 3 years? Do you understand that?
Yes.
So there's a minimum mandatory sentence of 3 years of initial confinement in prison, or a maximum of up to 12 and a half years. But that would only mean an additional 7.5 years of initial confinement. So 3 years mandatory, 7.5 initial, with 5 years of extended supervision. That's mandatory in the minute, and the mandatory minimum as well as the maximum. Do you understand that?
Yes.
Now, do you understand that if I thought it was warranted based upon the facts of this case, your history, all of the things taken together, that I should sentence you to a maximum possible penalty or any other sentence? Do you understand it's my decision to do so?
Yes.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney?
I did. Yes.
In particular, that section that's called the probable cause section, where it basically says what happened and why you were charged with these crimes. Do you remember that?
Yes.
For the most part, are those facts accurate?
Yes.
Are you pleading guilty to an OWI 7, 8, or 9 because you are guilty of that offense?
Yes.
Mr. McLaughlin, did you thoroughly go over the facts alleged in the criminal complaint with the defendant?
Yes, Your Honor. I reviewed with the defendant the allegations that he, the arresting officer says that he pulled the defendant over because he was swerving in a public highway, deviating the center line, and that therefore, pursuant to Terry v. Ohio, there was a basis to stop, and that following his stopping the defendant for the reasons stated, there was more than sufficient indicia of odor of intoxicants, evidence of impaired appearance and as well as impaired driving. And in fairness to Mr. Ronning, he admitted that all of these facts were true. So therefore, Your Honor, pursuant to stipulation and review, there is more than sufficient factual basis within the narrative report to provide a basis for the charge as well as adjudication.
Thank you. Has anyone made any threats or any promises to you, Mr. Ronning, for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you're telling the court you fully understand what you're doing today
Yes.
and voluntarily.
Yes.
Has your attorney represented you competently?
Yes.
Has he done a good job?
Yes.
Has he looked at this matter thoroughly?
Yes.
Has he discussed with you the evidence and the discovery in the case?
Yes.
Has he discussed with you any potential legal defenses or a lack of defenses in this case?
Yes.
And it's your decision to accept a plea and not proceed to trial. Is that correct?
Yes.
Are you satisfied with your attorney's services?
Yes.
Do you have any questions for the court or for your attorney before I proceed?
No.
As to count 1, operating motor vehicle while under the influence, 7, 8, or 9th offense, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 1. Count 2 will be merged and dismissed, will be dismissed and merged in with count 1. The judgment of conviction will be entered today. Argument, Mr. Schmidt.
Thank you. According to my ADA's notes, the court wanted to know Mr. Roning's criminal history because he has connection to other states. And part of my argument for why the court should do the 3 and 3 out concurrent to Minnesota has to do with that. So I'll start with that. Mr. Roning's criminal history shows he did 2 burglaries in the 80s, and then the rest of his history is drunk driving offenses and then various low-level misdemeanor offenses as follows. 1986, burglary, Wood County, Wisconsin. 1987, burglary, Douglas County, Wisconsin. 1996, disorderly conduct, Douglas County. 2002, Douglas County, operation after revocation. 2008, Douglas County, battery. Then in South Dakota, 1994, Yankton, drunk driving. 1994, Yankton, insufficient funds for a check in the 3rd degree. 1995, Yankton, simple assault. Minnesota, 2001, St. Louis, drunk driving. 2003, St. Louis, drunk driving. 2006, St. Louis, drunk driving. 2011, Crow Wing, drunk driving. 2016, Renville, drunk driving. And now 2025, Olmsted, drunk driving. So basically what his record shows is that from 2016 until our case, he had no drunk driving offenses, showing a 10-year period where he was staying clear of it. Then he got the drunk driving offense here where, because of the nature of his criminal history and driving record being multi-state and mostly old, law enforcement misread it and thought this was only an OWI 3, which is how he got released. 6 days later, after our incident date, is when he got arrested for drunk driving on that Olmsted one, which he's already been convicted of. He was sentenced on May 6th of this year for that Olmsted one. They sentenced him to 46 months with credit for 157 days. The sentencing order indicates the minimum term of imprisonment is 2/3 of the executed sentence, which I believe is, I used a calculator, about 32 months. There's like a fraction, a very small one after that. So I think if the court follows this agreement, the end result is his sentence is going to be a little longer, and it might affect his eligibility for programming through Minnesota. I think running it concurrent also enables Minnesota us to send him back to Minnesota and Minnesota shoulder the better programming. I think the criminal history reflects that he has a much stronger connection to Minnesota and a much more recent connection to Minnesota than here. I understand the sentencing memorandum shows that he has had connection to Wisconsin, but I think it's highly relevant that the vast majority of his convictions for drunk driving are Minnesota, almost all of them actually. So for those reasons, the state would ask that you follow the agreement. Thank you.
All right, thank you, Mr. McLaughlin.
My remarks are essentially consistent with Mr. Schmidt's, Your Honor. I think the primary point is that in my dealings with Mr. Ronning, he's fully accepted responsibility. He never disputed the charge of the facts. He waived his preliminary hearing. He's accepted responsibility. He admitted to me he was operating under the influence. I believe he faces, as I believe my client service specialist memorandum details, he faces significant incarceration and in Minnesota, plus supervision until 2033. So therefore, he is going to be under a long period of supervision in terms of community protection. I think the court wanted, and I referenced, and I made note of it, because I think the court wanted to know what Mr. Ronning's state of mind was. And I think my client service specialist does a good point in pointing out that his intrinsic motivation seems to want him to maintain and enhance his relationship with his daughter. He I think was frank with her, is that he has felt the weight of disappointment from his daughter in his behavior, and that at age 58 he has not only lost liberty, but he has lost life opportunity and damage to his important relationships. And perhaps better late than never, but that he is coming at this late age in life, that he appears ready to want to change his behaviors and regain the balance of his life in a positive fashion. We in the legal system tend to call that aging out of the system, but really, I think it means it reflects a realization, either because of the pain of what you've inflicted on yourself and your family, that the punishment component of your conduct is set in, and that it is a external motivation to change. So, Your Honor, I think in terms of, I think Mr. Schmidt has, basically he has these period of non-OWI related offenses in the 90s, but then after that, essentially it's a period of simply drunk driving offenses. Not that they aren't serious, but there was a serious gap in terms of previous convictions until recent. So therefore, Your Honor, for these foregoing reasons, and under, of course, the court is well aware of McCleary v. State and Gallion, our seminal Wisconsin sentencing laws, that we use the least amount of incarceration consistent with the triad of the need to punish, his rehabilitative needs, and the seriousness of the offense. I believe the joint recommendation of the parties meet the McCleary and Gallion factors, Your Honor, when taken into consideration of the totality of his circumstances with his current Minnesota sentence. Therefore, Your Honor, for those reasons, I'd ask the court to please adopt the parties' joint recommendation. I feel it is appropriate.
All right, thank you. Mr. Ronning, anything that you would like to add or you would like me to be aware of?
You state however you feel, Mr. Ronning. I did not prepare you. I just told you have the last word.
Yes, you can say no. You don't have anything to let me.
Or no, I think he does want to speak.
I just want to note that I'm looking forward to my 6-month intensive treatment program that I have arranged. And I also arranged to be released into sober living as well to help work with my program. And that's about it.
Yes. He previously mentioned to counsel, Your Honor, that there is a Minnesota intensive treatment program that he was motivated to try to obtain before he came over here, or came back here to be specific.
I think that would be great if you do engage in something like that. And I told you, and I fully believe your attorney has told you that there is a mandatory minimum here, no early release, 3 years mandatory. And you understand that?
Yes, I do.
And so if you're out early from Minnesota, but even if I figure the 46 months, let's just say you sit the full 46 months, but at 2/3, that would only be 2.5 years of incarceration. You would still need to come over to Wisconsin to serve the rest of your sentence. Do you understand that?
Yes.
Okay. All right. So, Mr. Ronning, I've read the memorandum. I've heard the arguments of both sides. I've heard your criminal history. You haven't had an OWI or DWI, as Minnesota calls it, since 2016, since you received ours. And then immediately thereafter, you received one in Olmsted, Minnesota. So 2 back-to-back. That makes it more serious. Had it only been 2016 until now, the 10-year gap, it could have been looked at as something different versus you were charged with this offense here, and then you were charged and convicted of another offense right after you were charged with ours. Operating while intoxicated is a serious offense, whether it's the first, the second, the third, but when you're getting up to 7, 8, or 9, I'm going to tell you, when you're getting up that high, and I'm going to say 10, you may have a lifetime sentence there. It may be the maximum possible penalty that somebody can sentence you wherever it is, because 7, 8, or 9 is saying you have an issue, you have a problem, and your problem is, and I'm going to tell you your problem is you have a substance abuse disorder, but your problem is the substance abuse order, you drink the alcohol, you drive. That's your problem. You drive. That's your problem. You drive. Now, have you had a substance abuse problem and you want to drink yourself until your liver fails? Good, great, grand. That's up to you. That's your choice. You get behind a wheel, you drive. That's your problem. That's a crime. And that's why we have 7, 8, or 9 and whatever you were charged with in Olmsted. It's extremely more serious. It's extremely more serious. We've had people with OW1s who have killed people, or OWI2s who have killed people or significantly injured somebody. You're just so super very lucky that no one was injured and no one was hurt. It's a weird thing that here in Wisconsin, our OWI first is a ticket, a forfeiture. That's it. It's just weird and not necessarily in the state's best interest. But that's where we are. But when you're getting up to these high offenses, it's not only more serious, it's absurd. It's crazy. We shouldn't even have to have people with OWIs this high. I do understand that you want to change, you're trying to change. You're 58 years old. You should have figured that out by now for a better path. And you have to, otherwise somebody could die. God forbid, an innocent person. I think that you are a risk to our community, and it's shown just in this offense alone and that conviction. But hopefully you're going to stay in Minnesota. Even after you're released in Wisconsin, don't come back. Okay, I'm just gonna warn you right now, don't come back to Burnett. I don't want my community at risk. For the most part, the agreement does make sense. And I understand the reasoning behind it. You are accepting responsibility right away, but you don't want to be punished more. You want the good old deal of serving the times together. But they're two separate incidents, two separate states, two separate dates, two separate times you drank intoxicating beverages beyond the legal limit and put people at risk. Two separate, all the things. So I just can't see that this is something that should be sat concurrently. But I don't know if it matters if I do it concurrent. You're going to be able to get out of Minnesota early with some types of programs, but again, you're not getting out. You're going to come to Wisconsin, you're going to sit your time, you're going to have a sentence. So you want to get out of Minnesota prison earlier, that's fine, but you're going to head on over to Wisconsin prison. With regards to this matter, the court does believe it is far more serious than 3 years in, 3 years out, concurrent. So what the court is going to do is I'm going to sentence you to 4 years initial confinement, 5 years extended supervision. You need more oversight on the end, and that means 5 additional years that can hang over your head, and you can sit more time in prison in Wisconsin if you do violate and you get revoked and sent back to prison. Very good reason to try and figure things out and go to the rehabilitation and treatment place. Because again, the next time you could have a life sentence because you could have killed a mom and 2 kids. The court is going to assess $5,523 in fines and fees plus a $10 blood draw fee. And even then, you're getting the benefit of the doubt. I'm only using the fines and fees for the fourth offense. Simply because I'm going to tell you, it's so hard to calculate and you're not going to pay it anyway. My gut's telling me that you don't have the money to pay it off anyway. The court is going to order, while incarcerated, you must make payments and it will be collected as a percentage from the Department of Corrections to be determined as reasonable by them while you are in prison and on extended supervision. They will collect these funds. This is a felony, no use or possession of firearm for life, no voting in any election until your civil rights are restored. The court is going to order absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. No alcohol, no bars, taverns, liquor stores, casinos, or any establishment that has the primary purpose for the sale or the service of alcohol. The court is going to order gainful employment because you're still going to be at an age where you can work. I know 75 or 80-year-olds that still work. Testing, regular alcohol testing. I'm also going to order something as thinking for a change or breaking barriers. There needs to be something there to help change that mindset. And I'm ordering an alcohol and other drug assessment and to follow all recommendations. You cannot be released from any supervision until all of those recommendations are complete. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. The court is going to order that if you fail to pay your fines and fees, not only will a civil judgment be entered against you, you're always going to owe it, but the court will issue a warrant and you could sit up to 6 months in jail. I need to order your DNA. The jail will make sure that we have that. This is not a crime in which you can have your DNA expunged. I think that covers everything, Mr. Schmidt.
Did the court make a finding on eligibility for SAP or ERP?
The court will make you eligible for early incarceration only after it has been shown that you have had 3 complete and full years in custody. No release earlier than that. And that can be calculated using time in Minnesota, including time in Wisconsin. But you must sit 3 full years before you're eligible for any earned release programming.
Second, is the court ordering it concurrent or consecutive?
I said concurrent.
Third, did the court order a revocation of his license?
The court will revoke, oh yeah, I haven't gotten to that yet. They still have to order OWI assessment and follow through. I did order an AODA. I also have to revoke your license and a revocation here. Up to DOT, but what are you asking the court to revoke? How long?
I'm trying to find what it is from the court. I know DOT is going to revoke it for life.
They will. I can look at my big old binder. Try and find that as well.
I apologize for not looking that up before court.
Well, just has to be on the record. So the court is going to order, I'm going to order 10 years revocation of driver's license, 10 years ignition interlock device, Oh, I can look at this right now. Here we go. Nope, all it says is holy guacamole.
I think it might be 4.
It is not. It's revocation of 2 to 3 years, I think. That's silly to me. 3 years of revocation of driver's license, 3 years of ignition interlock device. Holy guacamole. I can't believe that that has even ever been part of, should be a whole lot more than that. But your license most likely is going to be revoked from the Department of Motor Vehicles, the DMV. They'll figure that out. What else?
That's all from me.
Mr. McLaughlin.
Your Honor, I just want the court to make the finding, as I believe you already have, that because Mr. Ronning was under an existing executed Minnesota sentence at the time, that he therefore is not entitled to sentence credit in this case, and that's a part of our record.
That there's no sentence credit for here?
Yes.
Yes, there's no sentence credit for here.
And therefore, Your Honor, because the court has, Mr. Ronning understands that you've gone above the joint recommendation, but because you have recommended it concurrent, Mr. Ronning has told me, has given me authority to say that he is not at this time dissatisfied with the court's ruling. However, and I appreciate his accepting that. I think that shows again his acceptance of responsibility. However, he has 20 days from today's date to change his mind. Should he do so, he has the right to, within that time period, to seek relief to the Wisconsin Intermediate Court of Appeals. Services of his attorney continue in that time. Thank you.
Thank you. Mr. Ronning, just so I can be clear with you why I didn't follow the recommendation as it was recommended to the court. Again, it's because it's different dates, different times when you could have decided not to drive in different states. So there should be a different sentence, which means it should be something that would be more of a punishment because it was twice, 2 different times. All right, thank you. We are adjourned.
You didn't do badly.
No,
Thank you, Ms. Molsom. I think
You've only got like
that
another
covers
year
your
for-
services today.
That's not bad at all.
no.
Good luck, sir.
Thank you.
You're most welcome.
You're welcome.
Ask that it be set for a plea and sentencing in about 2 months. I believe that should be sufficient time to get everything set up.
All right. Mr. Roy, are you employed?
Yes,
Do you work Monday through Friday?
yes.
You work, what hours do you work?
6 to 3,
6 to 3?
yes,
So 3 PM?
yes.
All right. Where do you work?
Webster School District at the schools.
Okay. So if you're done at 3, would you be able to be here and ready for a plea and sentencing, knowing that you're going to go into custody immediately for the weekend? I'll do it on a Friday, if that works better. We can do it after work. And then you would be released in the morning on Monday. So does a Friday work better after 3?
That would work fine, yes.
Mr. Chapman, I could do Friday, the 25th. And we can do on September 25th at 3:30.
Yes.
All right. Usually I don't try and schedule things so late in the afternoon on Friday, so I can do some work and do whatever, but I'm A-okay doing this. So it helps your life better.
Thank
You're
you.
doing the IDIP program, so be expected, and your attorney will tell you if this is exactly a plea. It's going to be set as a plea and sentencing, but you will need to immediately go to jail. And again, you won't be released until Monday morning when they can put you on the monitor if the court grants you that ability. Okay.
Okay,
All right. So we'll see you Friday, September 25th at 3:30.
okay.
Okay, come on up and get your notice. We are adjourned, but Mr. DeRoy, you will be late on that Monday. So I would probably tell him you wouldn't be able to work until noon or so. Or you can take the whole day off if they'll let you. All right, thank you. Mr. Mason? On the record in the matter 26 CM 48. State of Wisconsin versus Cody Mason. The state appears through District Attorney Kevin Schmidt in person. Mr. Mason appears in person with his counsel, Joel Feliski. We're set today in this matter for an initial appearance. However, Mr. Feliski, are you aware of 26 CF 100, which has just been filed recently?
Thank you, Your Honor. I was notified this morning of that new filing. I did discuss that with Mr. Mason. I've also had a very brief opportunity to discuss that with the state. And based on that conversation with the state, it is my understanding that this new filing would impact any potential resolution we may be able to reach in this case. In addition to that, Your Honor, I've had an opportunity to review the discovery in this case. I've discussed that with Mr. Mason. Based on that review and discussion, I would like to look into a potential reverse other acts motion for this case. So I'm asking for another status conference in order to discuss terms with the state and look into that motion issue.
Okay, and that's for this misdemeanor case?
Correct.
With this felony case, can we just move his initial appearance from September 9th to now and we can just join these cases?
I would not necessarily have an objection. I do not have a complaint available for me
I
at this
sure
time.
can print one out for you.
I
so
would
you can
gladly
go
take
over
one.
it with Mr. Mason.
Absolutely.
And I so appreciate your thorough investigation and negotiation with the state on the other matter. It's going to print over here. You can come over here and get the complaint, briefly read it, or read it as long as you need to, and then discuss it with Mr. Mason, okay?
Of course, Your Honor.
While we are briefly off the record, Ms. Kirsch, thank you so much for filling in today. I so appreciate it, and I appreciate your services.
Of course, no problem.
Yep.
All right, back on the record, same appearances as previously noted. Mr. Feliski, were you able to go over that criminal complaint with Mr. Mason?
That is correct, Your Honor. I have reviewed the criminal complaints, including the charges and the maximum penalties with Mr. Mason. I do believe he understands them. We will waive formal reading, enter in pleas of not guilty as to counts 3 and 4, and would request a preliminary hearing on counts 1 and 2 within time limits.
All right, thank you. Not guilty will be entered as it relates to the both of those misdemeanors. You still live on Ellis Avenue?
No.
Did you say within time limits?
Yes, Your Honor.
It's going to be very difficult. It's most likely going to have to be in front of Commissioner. And so you won't be able to argue any evidentiary issue or motion on that day. Boom, boom, boom. I just can't do it. Commissioner's not here. And I have to, you should see my calendar. I'm double, triple booked on all the days. I'm out of county all day on the 21st. I can't do that, and Friday, and Mr. Schmidt, we're gonna have to miss some of our DJCC meeting. That's all I can cut. And that would be Thursday, July 23rd. And we could do 9:45 and cut into my meeting.
Take a moment to discuss this with Mr. Mason. Your Honor, I do see, looking at my calendar, I have a preliminary hearing in Polk County at that time. Okay. Discussing this with Mr. Mason, Your Honor, he's indicated that he would not object to having time limits waived for the preliminary hearing.
Mr. Mason, I really appreciate that. Thank you. And then perhaps maybe at that time, if you're able to get your other acts motion done, we could probably do both in the same time. So
Yes, ma'am.
that actually probably works out better.
Certainly, Your
How
Honor.
long do you think you're going to need to get your other acts?
Some of this is going to depend on my investigator. Unfortunately, I think looking at what we would have to produce, it would probably take me about a month.
And I would need time too, because I usually respond to other acts with a written one. And if they filed one, I would likely file one as well.
I am totally okay with giving all of the time. I just want to make sure that, because he wanted the preliminary hearing within time limits, that he is really okay with going that far out, because we're going to have to go to September.
I'm fine with that.
What?
I sound fine with that.
Okay. And can you just make sure that the
Sorry.
microphone is closer? It's just because, as you can see over here, I have a virtual court reporter here today, and she really needs to be able to hear everything and get it all down. All right?
Understood.
Okay. What about having the hearing September 11th? But how long do you think it's going to take for this other acts? It's not going to be too long. It shouldn't take too.
No, I think a month would be appropriate.
Yeah, but how much in time of a day? Like an hour?
Oh,
Half hour?
I think at most an hour.
Mr. Schmidt, what about you? Do you think it would be about an hour?
It's not an evidentiary motion, so I don't even know why we do oral argument, to be honest.
Well, we're going to have the hearing and we're going to have a prelim, so we're going to have the date and do the things. I can do September 11th, anytime between 9 and 10. And I guess we'll just set it for 15 minutes.
I think that'd be appropriate, Your Honor. I have full availability anytime in that framework will work.
Why don't we schedule it for 9:30 and we'll just block off a half hour just in case.
That will work.
Because if it's going to be a prelim, it might be a little bit longer than that allotted time, but we'll see. So September 11th at 9:30, okay?
Understood.
You can come up here and get your notice. So this is off the record, but so you're going to need a month to file it. You're going to file it in a month, correct?
Yes, Your Honor.
And so,
I mean, he's saying he needs to do investigation. Maybe we should wait for him to figure out he does have another acts motion.
well, okay. I'm just saying that just because I want to give timelines, if that does happen, so that you know when to file it by, and you
Certainly.
know when to file your response. If there is one, okay. If there's not one, that's okay too. As long as you're okay with, we're still going out that far.
I understand, Your Honor.
And
Right.
if by chance there isn't another axe motion that you find after your investigation and all of those things, and Mr. Mason and yourself, you would like to have a prelim earlier, because I could squeeze a prelim in earlier than September, but maybe. I don't know. It's pretty booked.
I'll notify the court as soon as I have reason to believe that that would be appropriate.
So let's just give you a deadline, and then I'll put that stuff on the record, but let's just say August 15th is your deadline. Do you think that's enough time for an investigation?
I think that would be appropriate. I think that'll be enough time.
Okay, so August 15th will give you as a deadline. And if there is one and something's filed, Mr. Schmidt, well, August 15th is a Saturday, so the 14th, I guess, will be the day. So I'll write that down. So I say August 14 deadline. And then Mr. Schmidt, do you think you can have yours done by the 28th?
August?
Yeah.
I can.
Oh, wait, did I look at the wrong one? No, I was in, okay. You think you can get it by August 28th? That's 2 weeks.
I'm promising something. I don't know if I'm gonna file it because I haven't looked into
I
it.
know, I'm just saying, just in case. Usually you get things done, I'm gonna say lickety split really quick. So,
I'll put a note, August 28th deadline for other acts.
I'm gonna
response.
say this on the record, and then our clerk Olivia will get it in the minutes, okay?
My main concern with your deadline is I thought your investigator was leaving. So like, I don't know how you're gonna do an investigation in a month.
Well, we've got Craig up in Superior, but that's best I can do.
Okay.
Okay. And if you need more time, something, just let me know too, and we'll figure it out.
Of course, Your Honor.
Back on the record, same appearances as previously noted. Off-record discussions with both attorneys as it relates to any evidentiary, any other acts motion and the preliminary hearing and timelines, et cetera. The court has ordered a deadline for August 14th for Mr. Flisky to be able to file his motion if one exists. After he investigates, he determines he needs to file that motion. And the court did give a deadline to the state for August 28th for any response to the motion. And then Mr. Flisky, you would have until September 4th if you want to reply.
Yes, Your Honor.
However, if something comes up because of your investigator situation, and if you need more time, and if Mr. Mason is okay with it, we can extend those deadlines and extend that hearing date. And if you discover that you did not come up with the information to file another acts motion, then we can attempt to get an earlier preliminary hearing.
I understand, Your Honor.
All right. Let me just verify Mr. Mason's information so that I know. Are you still at P.O. Box 134?
Yes.
He said yes. And your telephone number ends in 0365?
No.
6197?
No.
May I get a new one, please?
715-553-1004.
He said 715-553-1004 for
Yes.
the record. All right, maybe send you text messages?
Yes.
Okay, thank you. We will. Anything further?
No, Your Honor.
State.
Okay, then we are adjourned. Thank you. Yep. You can take all the time you need. Vicky, Miss Bauer, sorry, Miss Bauer. You look very nice today. Oh, thank you. Mr. and Irene. We're not gonna go right away. We just need a little bit of time so my clerk can catch up.
Excuse me.
We will go on the record in the matter 24 CT 60, State of Wisconsin versus Devin Nyreen. The state appears through District Attorney Kevin Schmidt in person. Mr. Nyreen appears in person without counsel. We're set here today in this matter for a status conference. Mr. Nyreen, you were in the process of getting your license. You've done some things. How close are you to getting your license?
As of 6 months ago, I was forced to relocate from outside of town here to Rice Lake. I was fortunate enough to get an apartment as well as a co-signer for said
Can you
apartment.
just make sure that the microphone is a little bit more towards you? It's just so my court reporter can make sure that she gets everything. Just like turn a little bit to your, like right to your mouth. Thank you.
Do I need to repeat the last?
I think she got it. We're good.
Okay. Anyway, I was forced to move. I got an apartment in Rice Lake. I did have a job, but my employer decided to sell post their business for sale. And since I was the newest hire, they, unfortunately, yes,
Okay.
I do have multiple apps out now. I had a call back from Rice Lake Weighing.
That's
Monday.
great. That's grand. That's wonderful. What I asked is, how close are you to getting your license? What steps do you need to do?
Due to what I said previously, none. I was handed the paperwork for the Barron County driving assessment, stuff like that, since that's where I'm located now. I was trying to look for it on my own time, but the lady out front handed it to me before I came in, all the information that I need to move forward in my current location.
One of the clerks?
Yes, ma'am.
That would be Amy. Probably she's amazing at doing these kinds of things.
Okay.
Okay, so you know what you need to do? And are you gonna have the money to do it?
The fees are a lot steeper down there from what the paper has shown. Along with my rent.
Breathe in the microphone, just talk in the, I'm sorry, it's just, I need my court reporter to
I
be able to
understand.
understand.
It's possible, yes. It may take more time now that I have rent to pay.
All right, so here's the deal. You have $694 posted in this case because you missed court. Bench
Yep,
was issued, you have $500. You need to give me all of that information. I'm setting a hearing, a status conference, very short turnaround. I don't care if you appear by telephone or by Zoom, just like my court reporter is doing here today. I just need an update. Here's the deal. I want you to get your license. Mr. Schmidt wants you to get your license. The offer is do what you need to do, get your license, and the matter will be dismissed completely, okay? Or you can plead to the charge for costs. And here's your options. You can plead to that charge right now, and I'll do it here today if that's what you want to do for costs. You have enough posted, you'll probably even get more money back. So if you want to take that part of the offer, that offer part, you can. Or you can say, you know what, Judge, I want to get all of the information I need. I want to know how much it's going to cost, the steps I need to take, and how long you need to tell me how long it's going to take you to get your license. And what the court would be willing to do there is if you say it and show me proof, it costs $300 to take this assessment and only $100 to do whatever. I will divert or ask that money to be sent directly to those places, not giving it to you, directly to those places so that that money can be used for those purposes. I just want to make sure that this case is going to be resolved timely. It's 158 days. I'm not too concerned about that. It's not too long, too old. So those are your options, okay? You can plead to the charge for costs, be done here today. You'll get money back. You can have a status conference in a couple weeks. I don't care if you appear by telephone or Zoom, and you update me exactly of what you need to do. And somehow you provide me proof of, here's the document. It says $380. Please divert this or send this money to Barron County Driving Assessment Program or whatever it is. Okay, so those are your options. Is this your wife who's here with you today?
No, ma'am, that is my mother.
Well, your mother looks great.
Thank you.
So, all right. So what I can do right now is take a brief little recess, allow you to go talk to your mom, have some conversations, come back. You can update me on what you want to do. Again, we can resolve it today, be done, and you'll get money back, or we can continue down that path, okay? In a second, we're gonna go off the record. Your question is not gonna be on the record, but you can ask me a question. So please project your voice.
So if we were to resolve today and it goes away,
Yes,
say 2 years down the road, he wants to get his license back, is in a better place financially, whatever. Is this going to come back?
Nope.
Or
nope. He just has to do what he needs to do. This may cause a little bit more of a delay in the DMV to give him a license. I don't know exactly all that, but if it's 2 years and it's been 2 years, that shouldn't be a problem. If it's gonna take him 2 years to get his license, and you guys fully know that, you think he just needs to be in a better place, he needs to be more stable, and you're good with driving him wherever he needs to go.
he kind of lives within
I live.
most things.
Okay.
So
So, yes, after whatever, Mr. Schmidt, you can answer a question too if you want.
The two things that could affect his license is if he has an unpaid fine, they could use that to suspend his license. If he already has that paid and she's fully resolving the fine, that can't possibly happen. The second thing is when you get certain tickets, like this in Wisconsin, you get points against your license. Points expire after a year. So if the plan is to do it more than a year out, the points would have already expired.
So those are your options. What I'm gonna do, I'm just gonna have you guys just go talk outside, talk amongst yourselves. Let me know. We'll figure it out. Okay?
Very well. Thank you.
Ms. Campion, Mr. Chanel, can you hear me?
Yes.
And I don't think I'm gonna need Mr. Chanel to do any speaking, but Mr. Chanel, you're kind of coming across a little quiet, but I don't think I'm gonna need you to speak probably, because I'm gonna talk to you, Ms. Campion. We will go on the record in the matter 26 CF 12, State of Wisconsin versus Richard Chanel Jr. The state appears through District Attorney Kevin Schmidt in person. Mr. Chanel appears by video conferencing, as does his counsel, Emma Campion, approved by the court. We're set today in this matter for a status conference. Ms. Campion, can you please update the court?
Thank you, Your Honor. We received new discovery on, hang on one second. I think I have a sound issue on my end. My apologies. We received new discovery on Monday that I think is in impact negotiations. I have not had a chance to talk to the state about it. So I'd ask for an adjournment, one more status conference. I don't think we'll need much time. I think 2 weeks, 3 weeks is fine. But because of the new information that came in on Monday, I'm not prepared to tell the court, unfortunately.
Okay.
Basically, lab came back with unusual results.
Interesting. I can't, I don't get to hear or see those things, but I like to hear about them. Okay, so you're saying, do you really, really want a status back on the record? We are in the record, I think. Do you really, really want a status in 2 weeks, or do you want something a little later is okay? What
A little
exactly
later
are
is
you looking for?
fine. I don't have a problem with pushing it out. If the court and the state were concerned about progress, I'm fine to have it sooner, but we can push it too. I'm not super particular.
Ms. Campion, I fully trust that you're doing your job. I fully trust that you are negotiating and working with the state as you can as a defense attorney. I'm not too concerned. How about August 13th? And we can do I can probably squeeze you in anytime in the morning.
If it's Zoom, that should work. I could do probably anytime after 10:30, or I could do 9. I have a 9:30 pretrial block in St. Clair County that likely will take an hour.
I could do 9. It's just going to be a quick little hearing. I have another one scheduled at 9, but that's going to be quick too. And I can do yours first if you need to make sure you can skedaddle, and Zoom is fine.
That works for me then.
And Zoom's fine for you too, Mr. Chanel, okay?
Yes, ma'am.
Okay, see, I really can't hear you though, so I don't know if I need you to speak, you're gonna need to be in a different way in Zoom, or just call with your telephone.
Sorry about that.
Oh, now I
Oh,
can
that's
hear you.
much better. That's much better. Okay, thank you. So we'll see you August 13th, 9 a.m., okay?
Sounds
Yes.
good. Thank you.
Thank you.
All right, thank you. We're adjourned. Back on the record, same appearances as previously noted, 24 CT 60, State of Wisconsin versus Devin Nyreen. Mr. Nyreen, please update the court. What is it that you're looking at trying to do?
I have agreed to nip this today.
Nip it in the butt
Today.
today and get her
Today.
done.
Yes, I did have a question. Since we are going that route, and I understand that some money may come back, whatever. Later on down the road, as was mentioned earlier, 2 or 3 years when I'm in a better place, would I still have to do the AODA assessment?
Yes,
Yes, okay,
you will always have to do those.
right, okay.
Otherwise, you will not get your license. So you can
Just
take,
clarify.
let's just say it's taking you 3 years and but you are finally stable. You have your rent paid, you have your house, you have money to buy a car and all of those things. Yes, you will still need to do that
Right, just at that time.
at that time.
Perfect, okay, yes, exactly.
Technically, you are ordered to do that at the time of the OWI, but that's what they're gonna say.
Right.
Because they're gonna say, you have to do this, this is what you have to do, you do it, and you can get your license, all right?
Absolutely,
So you wish to accept the offer of plead to the charge for costs?
yes,
Okay. Now, Mr. Nyreen, how old are you?
27,
Can you read, write, and understand the English language?
yes, ma'am.
Any drugs, alcohol, or other medications that you've had today?
Not for a long time.
Not for a long time?
I'm still sober from alcohol since the last time I saw you.
I'm so proud of you.
Yes,
That
ma'am.
really is excellent. How many days have you been sober?
I lost count. It's obviously gone over a year or for a while. And then trying not to think about it.
I am so proud of you.
Thank you.
And I know it's hard. Each and every day it is hard, and but you are conquering it every day.
Yes, ma'am.
Okay, so do you understand that you would have the right to an attorney?
Yes,
And do you understand an attorney is in a position where they go to law school, they practice law, they do these things, and they're able to understand the law, read the law, and they can negotiate with the state or argue and make arguments to the jury, such as defenses and those types of things?
I understand. I look at myself as more of an honorable person than that, and I like to speak for myself.
Appreciate that. Do you understand that not having an attorney, though, is the opposite of those things, because they're not gonna be able to, you won't have the legal ability to be able to look and say, well, do I have a defense here? What can I argue? Is there any better deal I can get?
I understand.
Okay, now, do you understand you would have the right to a trial? You would have the right to have, you would have the right to testify on your own behalf or remain silent and not have your silence used against you. You'd be able to have that jury trial in which 12 of your peers would be able to listen to a trial and hear it, and they would need to make a unanimous decision as to whether or not you're guilty or not guilty. You would also have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
Yes, ma'am.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand that you're pleading guilty to the count of operating a motor vehicle while revoked? The state would have to prove on or around May 27th, 2024 in Burnett County, Wisconsin, while being a person whose operating privileges have been revoked, that you did operate a motor vehicle on a highway or roadway of this county during that revocation period or thereafter, and the revocation was a result of an OWI or similar offense.
Yes, I understand.
You understand that upon conviction, you could be fined up to $2,500 or not more than 1 year in the county jail or both.
Yes, ma'am, I understand.
You understand that there is an agreement here where the state has agreed to recommend to the court costs only, but I don't have to follow that if I think that this was serious enough. Do you understand that?
Yes, ma'am.
I could sentence you to the maximum possible penalty if I thought it was warranted. Do you understand?
Yes, ma'am.
Do you still wish to proceed and enter a guilty plea?
Yes, ma'am.
Are you admitting here today you in fact did operate a motor vehicle on a highway or roadway of this county and state?
Yes, ma'am.
And are you admitting here today that you in fact that your driving privileges were revoked and you knew they were revoked?
Yes, ma'am.
Do you have any questions for the court or for Mr. Schmidt before I proceed?
No.
Has anyone made any threats or any promises to you for you to plead guilty today?
No, ma'am.
Are you doing so freely and intelligently, telling me you fully understand what you're doing
Yes, ma'am.
and voluntarily?
Yes, ma'am.
Then I do find that you are competent and you are freely and able to represent yourself. And you're rightfully, knowingly, and intelligently waiving your right to an attorney and to a jury trial. As to operating while revoked, a misdemeanor, how do you wish to plead?
Guilty.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of the sole charge. A judgment of conviction will be entered today. Argument, Mr. Schmidt.
Doing the cost is appropriate in this case. This defendant lost his license from an OWI from 2020. He's only had one prior OAR, and it was in 2021, so it's been a long time since then. The only warning I'd give him is if he waits too long, if you go 8 full years without a valid license, then you need to retake the written and field driving test again. So he would behoove himself to get his license back before 2028. That's all.
Okay. Mr. Nyreen, is there anything you want to tell me? Anything you want to let me know?
I'm trying. That's about it.
Make vast improvements.
His mom said he made vast improvements. I'm so proud of you. I really, truly am. And I hope you're proud of yourself because this is a big deal and it's a big step.
Yes, ma'am.
Taking control of your life and control of your path and control.
What started as a routine restitution hearing quickly turned into one of the most intense legal battles in the courtroom. Defense attorney Tripp Stroud challenged the prosecution's evidence, arguing that the state's restitution claim relied on documents that didn't match the original property records. The turning point came when the judge closely compared Exhibit 2 with Exhibit 4 and noticed that several high-value gold coins appeared on one list but were missing from the expert's signed inventory. The courtroom immediately shifted from a simple financial dispute to a serious debate over credibility and evidence. As the prosecutor defended the state's position, the judge repeatedly questioned the inconsistencies, making it clear that every document would be carefully examined. The defense insisted the missing items dramatically inflated the restitution amount, while the prosecution argued the defendant had already agreed to the value as part of the plea agreement. Even after acknowledging that the defense had presented a persuasive argument, the judge reminded both sides that a signed stipulation could not simply be ignored. With both attorneys standing firmly behind their positions, the hearing ended without an immediate ruling, leaving everyone waiting for the judge's written decision on one of the case's most disputed issues.